the view has been that the common law is judge-made law, that state courts' job is to develop state common law, to choose the best rule that they can, recognizing that, that best rule may be affected by the existing lines of precedent and concerns for stability and predictability and so on. But ultimately, it's their job to make state common law. And it's the federal court's job to follow and sometimes even guess about what kind of law they're going to make. And to also maybe to do a little bit of lawmaking in the areas of their own exclusive jurisdiction, hence things like federal common law. And my view is that that whole view of law is wrong, that the common law is not or does not have to be judge-made law, that it can also be judge-found law, that it can be the job of the judge to identify law that is not of their own creation, that's already there in some sense, and that they play the role essentially of an AP exam grader whose job is to rate something according to standards of grammar and syntax that they do not themselves create, or maybe more appropriately a Miss Manners columnist whose job is to assess the situation that people write in about according to standards of etiquette that are not of their own creation, in ways that may influence others' judgments. If you have a successful Miss Manners columnist, they will in some sense make etiquette over time by causing people's views to be different, but that's not their remit. Their job is to apply existing standards as best they can to the circumstances that arise before them.